Hello everyone, welcome to GS Core, and I hope you have done well with respect to your mains examination. What we will be doing in this session is we will be going through the questions of polity, alright, of your mains. So let us take into consideration the first question. The first question is examine background of Sarkariya Commission. Okay. Now if you look at this question and if you look at other questions also of polity, we'll go through them. The questions basically are on the basis of what is happening in current affairs. Okay, if you take into consideration the questions now, they are the mixture of current affairs and static syllabus, as we had seen during syllabus explained videos also of GS Core with respect to Odisha PCS. So the questions are on that line. Alright, questions basically are on that line. Now Sarkariya Commission, the question on Sarkariya Commission has basically been asked because there is basically rechurning with respect to the thought process of center-state relations. Alright. Isiliye what we also see, that is the reason what we also see is the Home Minister has asked the state governments to take into consideration recommendations of Punchi Commission. They have not asked about Punchi Commission, but because Punchi Commission was in news, what they have done is they have asked question related to Punchi Commission, and that is Sarkariya Commission. Okay. Overall, from current affairs, that what they have taken, they have taken center-state relations into consideration. Okay. They have basically taken center-state relations or state-states relations into consideration for the purpose of identifying your knowledge base. है ना? तो पहला क्वेश्चन है examine the background of Sarkariya Commission. So if you look into this question now, if you basically look into this question, it is not as such difficult. Alright, though what do you have to understand or what do you have to know is that Indian Constitution and the implementation of Indian Constitution is not just a legal process. It is not just a legal process. It is also a political process. And hence, you have to take into consideration the politics of that time. Okay, if you have to take into consideration the politics of that time for the purpose of understanding what has to go in this answer. This question was basically for 10 marks. And hence, what is expected from you? Your answer should be around 150 words. That is how UPSC also calculates, and that is how OPSC will also calculate, take into consideration. So 10 marks ka hai na, around 150 words you have to write in this particular answer. Alright, what will be my answer in this particular question? My answer basically will start with India being a federal country. Okay, India being a federal country. And as a federation, it basically has two units. These units are center and state. Basically center and state. Alright. And because India has two units, what do we also see? Issues with respect to workability of two systems within one constitution. Workability of two units. Workability of two units. Sarkariya Commission was basically appointed in 1983 for the purpose of examining its workability, and making recommendations to make it better. Alright. Now recommendation is not asked in this question, so we will not go to recommendations. Alright, for the purpose of this question, it is asked in another question, we will look into it. What they are asking is background. ठीक है, background. तो background के लिए और एक line लिख देना. Sarkariya Commission was established under the following background. It was basically set up because of the following background. Now, which were those backgrounds? Which were basically those backgrounds? ठीक है. First, obviously is difficulties. Difficulties in implementation of federal government. Now we had taken federal government and there were reasons for it. Alright, we have taken up the structure of federal government, there were reasons for it. But idea and implementation are two different things. Once we implemented the federal system, what we saw? We saw issues that bothered. Issues basically that bothered the workability of the government or exercise of power by the government. Alright. And to do away with those particular issues, Sarkaria Commission was appointed to look into it. Okay. Second background was establishment of non-Congress governments. Non-Congress governments. देखो, till the time that Congress was in power in both center and in the states, most of the issues related to interstate conflicts or center-state conflicts, they were resolved through the party. Alright, through the mechanism of the party. But once non-Congress government started coming up, for example, Kerala, for example, Tamil Nadu, for example, Bengal, West Bengal, what also started happening was coordination between governments of different parties became difficult, and how that governmental coordination could be streamlined, that had to be looked into. So formation of non-Congress governments was also one of the reasons why Sarkaria Commission was established. Then of course was issue with respect to the office of governor. The office of governor since the time of independence have been playing partisan roles. To an extent, don't write this directly, but governors basically have not been neutral, or they have basically not played the role that was expected from them. They have not played that role to the fullest, and because they have not played the role to the fullest, what basically happened was state governments had grievances against this office. Not only that, appointments to the office of governors also became controversial. Most importantly, you can say, when Janata Party came to the power, what it basically did was it dismissed governors at a mass scale, and the same Congress did in 1980 when it came back to power. So stability with respect to the governor's office, especially with respect to appointment and dismissal, and also working of the office itself in the way that it remains inclined towards the thought process. It remains inclined towards the thought process of the founding fathers. That became very essential. That also had to be basically examined. We have to also take into consideration 42nd Constitutional Amendment. This is another background. 42nd Constitutional Amendment basically is another background for the purpose of setting up Sarkaria Commission. 42nd Amendment, what it did was, it passed on certain powers, it passed on certain subjects from state governments to the center government. From center government, yani what I am saying is from state legislature to the parliament. 5 subjects basically were taken from second schedule and passed into concurrent list. That means central government could also make law on it. Central government basically could also make law on it. Parliament basically could also make law on it. Not central government, parliament basically could make law on it. Alright. And because parliament could now make law on it, powers with respect to state governments were reduced. Alright. Powers with respect to state government with respect to those subjects were reduced. Also, by 1983, when Sarkaria Commission was established, what we saw is emergency. Proclamation of emergency, implementation of national emergency. Now this created a centralizing tendency in the governmental structure of India. Alright. And hence, for the purpose of knowing how to reverse this process, Sarkaria Commission came into play. Sarkaria Commission basically came into play. So more or less what we see is this were basically the background. Alright, which led to clash of interest between center and state government and between the state governments also, and therefore what we see is establishment of Sarkariya Commission. ठीक है, setting up of Sarkariya Commission. So this was with respect to your first answer. Now let us go to the next question. Let us basically go to the next question, which is inclined towards, which basically is inclined towards, this was for 8 marks, not 10 marks, sorry, it was for 8 marks. So more or less 100 words will suffice for this particular question. 100 words will suffice. Okay. So if you take into consideration the second question, examine the major recommendations of Sarkariya Commission. This question is for 120. This question basically is for 12 marks. So यहाँ पे ना you are expected to write around 150 words. 120 marks का question है, sorry 12 marks का question है, तो you are expected to write answer of about 150 words. Recommendation of Sarkariya Commission ना in that way are lengthy. ठीक है, what you need to do. So whenever recommendation of a particular commission is asked, take into consideration those recommendations which are most relevant in today's day and age. ठीक है, which are most relevant today, वो लिख देना. That should be your priority. That basically should be your priority. What will you mention with respect to recommendation, major recommendations of Sarkariya Commission? So if I had to write this answer, I would basically state कि Sarkariya Commission, what it tried to do is it tried to streamline the working of center and state government, and within the state also, within the states also. ठीक है, it majorly tried to create an environment of cooperative federalism. देखो, using buzzwords is very important. Using those words which highlight your point, na, that is very important. Even if cooperative federalism as a concept was not talked about at that point of time, but whatever Sarkariya Commission recommended was on the basis of cooperative federalism. In fact, if you take into consideration the report itself, na, so at that point of time, even if cooperative federalism was not the buzzword, the report did contain this term. It was not highlighted that much. It was basically not highlighted that much. The term was highlighted after, Prime Minister Modi started using it. At that point of time in 80s, it was not a buzzword as such, but it was there. It was part of the report. Hence, we have to use this particular word also, and it will make your answer, it will elevate the level of your answer also. So, this particular answer mein na, I will start with, in this answer what I will do is I will start with कि it was basically created for the purpose of streamlining the working of center and state, and hence creating conducive environment for the purpose of cooperative federalism. For this purpose, it provided certain recommendations. The report of Sarkariya Commission na, there were basically two reports. One was of recommendation and another was with respect to the inputs, the memoranda. ठीक है, तो basically the inputs that the state governments had basically given. ठीक है, we do not have to get into recommendations that state government had given or inputs that state government had given. We have to basically focus on recommendation. So recommendations में what all will be involved. As I told you, start with something that is most relevant in today's time and age. So the first thing that I will mention over here is basically about appointments of governor. Appointment of governor. So what did Sarkariya Commission speak when it emphasized upon the working of the governor? Sarkariya Commission basically stated that appointment of the governor should be as far as possible of a person who is non-partisan. Non-partisan का मतलब क्या है? A person who is not inclined towards a particular political party. Alright, second thing, Sarkariya Commission also wanted involvement of Chief Minister. Involvement of Chief Minister in the appointment of governor. And third thing was with respect to the governor not being from the state where he is appointed. Governor not being from the state where he is appointed, so that neutrality of office could be maintained. And basically petty politics will not come into the implementation of the constitutional provisions or legal provisions through the office of governor. All right. Next recommendation which you have to take into consideration is with respect to welfare schemes. Sarkaria Commission wanted empowerment, more empowerment of states for the purpose of programming and implementing social welfare schemes. Okay. This is also a point which is relevant from today's point of view. Why? Because if you take into consideration, the way in which central sector schemes are designed, what has been said, they do not take, the central sector schemes basically do not take state governments into confidence, they do not take the advice of state governments into consideration, they do not take inputs of state government into consideration. Even the implementation of it is done to a large extent by central government. All right. And states have very little role to play in it. So Sarkaria Commission had said empower the state to do the same, empower the states to basically implement in more effective manner social sector schemes or welfare schemes. All right. Sarkaria Commission also wanted, for the purpose of cooperative federalism, for the purpose of greater coordination between center and states themselves, the establishment of interstate council. All right, we have established this particular council. Article 263 of the Constitution calls for President to establish this council, and President of India has established this council. How effective it is, we will see in one of the questions, but this was one of the recommendations. Also, Sarkaria Commission was of the opinion, even if it wanted states to be empowered, it was of the opinion that All India services should be empowered even more. They should be basically empowered in even more. With respect to state bills which are reserved for the consideration of President, the time period that Sarkaria Commission set was 6 months. So if a state bill basically is reserved by the governor for the consideration of President, so that particular state bill, all right, has to be passed or has to be rejected within 6 months. All right. So time limit for veto was suggested to be 6 months. All right. Time limit for veto had been basically, confined to 6 months. Also, with respect to deployment of armed forces in India, it was Sarkaria Commission had recommended that there should be basically, consultation between center and state government. At this point of time, there is no provision for the purpose of consultation between center and state government when it comes to deployment of armed forces. Okay. If you take into consideration today's provision, so there is no such consultation wala provision Sarkaria Commission wanted. At this point of time, or even at that point also, center had full authority with respect to deployment of armed forces. All right. Last but not the least, taken into consideration today's positioning of Indian federalism, what we also see was Sarkaria Commission wanted Article 356, the one related to state emergency, to be used only in extreme cases. All right. So these were the overall recommendations of Sarkaria Commission. These were the overall important recommendations of Sarkaria Commission. Okay. In fact, what you will also mention with respect to appointment of governor is Sarkaria Commission wanted a panel to be established for the purpose of appointment of governor, which included Chief Minister of the state, Vice President of India, and also the Speaker of Lok Sabha. They should be consulted for the purpose of appointing governor of the state. So these were the recommendations. Some of the recommendations basically were accepted. Some of them were followed but not made legal provisions of, and some were ignored. Some basically were ignored. So these were the recommendations of Sarkaria Commission. These were basically the recommendations given by Sarkaria Commission. Moving ahead, guys, moving to the next question, and this is basically based on current affairs. थोड़ा सा पीछे गए हैं ये लोग, ठीक है. So it is something that had happened. It is something that had happened in 2019, but then Article 35A and Article 370, they become important because Supreme Court in recent times had passed orders with respect to constitutionality of 35A, constitutionality of the measure to do away with 35A and 370. All right. So on that, Supreme Court had passed a decision, and on basis of that decision of Supreme Court, the question has been asked to you. The question basically has been asked to you. All right. So let us now move to Article 35A. What does the 35A article explain? What does basically 35A article explain, and what were its implications? What were the implications of its being removed? So Article 35A of the Indian Constitution. Article 35A of the Indian Constitution, what it did was, it provided certain rights to those belonging to Jammu and Kashmir, to those citizens belonging to Jammu and Kashmir. All right. Just let me open the file. Okay. And therefore, what we saw is a distinct identity with respect to rights over property. A distinct identity with respect to rights over property being created because of 35A. Already been created because of 35A. What 35A basically did was, it provided the power to the Assembly of Jammu and Kashmir, to define who permanent resident, is. ठीक है. And once it defined who basically permanent resident is, what basically happened was, rights with respect to purchase and ownership were confined. ठीक है. What it also therefore did was, it affected the voting rights. It basically affected the voting rights of Indians who did not have permanent residency of Jammu and Kashmir. Okay, it affected their political rights, because if I went to Jammu and Kashmir when 35A was operative, I could not basically become a voter in Jammu and Kashmir. I basically could not become voter of Jammu and Kashmir. It also rejected the right of government employment to those without permanent residency. It rejected the right of permanent employment to those without, it rejected the right of government employment to those without permanent residency in Jammu and Kashmir. So it also violated Article 16. It also basically violated Article 16. And last but not the least, access to higher education. Access basically to higher education was confined to the people having the tag of permanent residence. ठीक है. तो Article 35A was a temporary provision, and it was for the purpose of internalization of the fact that Kashmir has become part of India. All right. And once that process was felt to be completed, it was also understood that there is basically no requirement for creation of two classes of citizens within India. That is, Indian citizens having permanent residency in Kashmir and the rest of Indian citizens. All right. What it will also do is it will push for better integration of Kashmir with the people of Kashmiri people with rest of India. All right. This was about 35A. This was basically about 35A of the Indian Constitution. Moving on to the next question, guys. All right. This question is more specific. This question basically is more specific when it comes to Article 370. When it comes to एक मिनट. Okay. So Article 370 was thought to be, my dear friends, was basically a temporary provision, for the purpose of, as I told you, internalization of the fact that basically Kashmir had become part of India. ठीक है. Kashmir had basically become the part of India, and it was due to Article 35A and Article 370 that special status and domicile laws for the purpose of Jammu and Kashmir were prevalent, and they were carried forward. They were basically brought forward. Now what it did was it created a differentiation. It basically created differentiation between whom? Between Indian citizens in J&K and rest of Indian citizens. Basically rest of Indian citizens. Now once this was taken away, once 370 and 35 went away, what basically were the positive steps? What basically can be taken into consideration to be the positive step which is leading us towards better national integration? वो है ना question. So first and foremost, what it did was it took away a mental barrier. It took away a mental barrier that Kashmiris and Kashmir in a way are different from rest of India. Alright, it took away that particular barrier. Second thing that it did with respect to Kashmir and with respect to rest of India is it opened up Kashmir for the purpose of rest of Indian citizens to invest. ठीक है, it basically opened up Kashmir for rest of Indian citizens to own a piece of land, to do business. All right, and therefore think of Kashmir even more as part of India. Think of Kashmir even more with same respect as the home state. All right, what it basically also did with respect to national integration was it took away chance of sentiment being growing. It took away chance of sentiment being growing with respect to secessionist activities. ठीक है, what it also basically did was it communicated to the people of Kashmir and to the separatists. It communicated to the people of Kashmir and also to the separatist group that basically Kashmir is part of India, and basically Kashmir and basically any provision which in a way could have the potential of creating a divide between rest of India and Kashmir will not exist. All right, it will basically not exist. What revocation of special status and domicile law also did was, it opened up Kashmir for the purpose of the laws of parliament to be implemented without every time taking the approval of state assembly. देखो, laws of parliament have to be applied throughout the country according to the provisions with respect to it mentioned in the constitution. If laws of parliament can be applied throughout the country without taking into consideration state assembly each and every time, then the same should apply to the Kashmir also, same should apply to the state of Kashmir also. That happened. Also what it did was it basically provided a direction for the purpose of similar actions in other parts of India. All right. So in other parts of India where such provisions basically are being provided. ठीक है, in other parts of India such provisions are basically are provided so that people can accept integration of that part with the rest of India. तो वहां पे क्या हुआ ना, एक example has been set out. One example has been basically set out. So these are the positive steps. These basically are positive steps which will put us on the right track towards better national integration. Also, if you take into consideration, once permanent residency had gone, ठीक है, identity of a Kashmiri, political identity of a Kashmiri now is not based on duality. ठीक है, now it is not based on duality. the citizenship of a Kashmiri now is inclined only towards being the citizen of India, not being the citizen of JNK and being the citizen of India. Okay. So the concept of one citizenship, what happened to is it bounded in a better way. The concept of one citizenship basically bounded in a better way. All right. So this was the answer. This basically should be the answer to the question provided with respect to national integration. All right. Moving on to the next question, guys. Moving on to the next question. And this is with respect to legal status of women. Okay, 363 revocation. Just a minute. Okay. This is with respect to Article 363 of the Indian Constitution being the legal custodian of center-state relations. So if you take into consideration Article 363, now Article 363, what is Article 363 all about? What is Article 363 all about? Article 363, my dear friends, is with respect to interstate council. Interstate council. All right. And the way in which 363 has been, the way in which 363 has been placed in the Indian Constitution, what does it provide? It provides a framework. It provides a framework that will basically safeguard federalism in India. That will basically safeguard federalism in India. Okay. So what has happened because of 363 is a provision is provided where delegation of center-state relations, can take place. All right, what does it do is it provides the President of India with the power. It provides basically President of India with the power through which, what basically he can do, he can establish the interstate council. What should be the purpose of the council? According to Article 368, what should be basically the purpose of the council? The purpose of the council is basically simple. It should focus on, the council basically should focus on creating a dynamic platform for discussion on policy matters and addressing issues with respect to center and state relations, with respect to center and state government. All right, moving ahead. Okay, moving ahead, what it also tries to do is, it tries to mitigate the trust deficit that over the period of time has developed between the center and state government. Center state council Interstate Council basically under Article 236 also has taken care of. It has basically also taken care of representation of states when it comes to federal relations, when it basically comes to federal relations. If you take into consideration of, or if you basically observe the way in which the composition of the council is, what do we basically see? We see Prime Minister to be the chairperson, but the members of the council to be chief ministers of all the states and union territories also, which have chief ministers. What it also shows is the representation of states is present, but overall an upper hand in the council is played by central government. Upper hand in the council is played by central government. Now this is not necessarily nothing, it is not necessarily something that will, that should, invoke a negative reaction, because Indian federalism basically is based on quasi-federal mentality or quasi-federal attitude. ठीक है, what Indian federalism overall has done is it has given power to the states, but overall the control over governmental system has been of the center, and interstate council under 263 represents the same. What it also tried to do is it tried to create a forum. It tried to create a forum which would advise rather than push for conflict resolution. So it provided for a conciliatory tone. It basically provided for a conciliatory platform. And through this platform, therefore, a better system of interstate relations was tried to be established. All right. Now going on to the next question, guys. Again, it is related to the same topic. So what we have seen is, हम लोग क्या देख रहे हैं ना actually में, what the State Service Commission has done is, it has taken up a topic and then it has asked you to focus on an important issue with respect to that topic in two different questions. ठीक है. So interstate council में पहले what they have done is Article 263 के बारे में, upon Article 263 they have asked you an overall question with respect to Article 263. Then what they are doing is they are getting into specific issue with respect to 263, and that is the role of interstate council when the provision is actually implemented. ठीक है. तो overall Article 263, how it will help Indian Federation, and then issues related to workability of 263 they have asked in another question. So this is what they are doing. ठीक है. And this you have to basically keep in mind while preparing also. Those who are preparing next year, you have to keep in mind this particular format. So if we take into consideration interstate council, what has to be in the beginning of it? शुरू किसे करें? शुरू करना है, you have to start the answer basically with stating that interstate council is provided for in Article 263, ठीक है, which allows the president, which empowers the president to create the council. ठीक है. And the same was done by the president on the recommendations of Sarkariya Commission. ठीक है. Other thing that you have to keep in mind in the introduction itself is with respect to its advisory role. ठीक है. You have to mention it in the beginning itself कि ये commission जो है it plays an advisory role. Also mention कि through it conciliation is expected in inter-state relations rather than the solution being pushed rather than the pollution basic rather than the position of the central government being pushed on the states. Okay. Then what you have to do is you have to showcase how this body is advisory in nature. Okay, this body is advisory in nature. For that purpose in the main body of the answer na do mention interstate council does not have the power to pass binding orders on either state government or central government. It is basically a forum that discusses issues and then provides advice on the same Also, what it does not basically have is machinery to implement its recommendation. It lacks machinery basically to implement its recommendation. What we also see with respect to interstate council, because it is advisory in nature, most of the time its recommendations are not complied with. That means effectiveness कम है with respect to the council. The frequency of its decision being effective are less. Also because it is not binding on the center or the state. To implement the decision, many a times the council is not taken seriously. Alright, the decisions of the council are not taken seriously. Alright, the council has also become the forum of political rivalry. The council has also become the forum of political rivalry, which basically does not allow the council to take up serious work. ठीक है? What we also see with respect to the council, the frequency of meetings. Of the council has dropped significantly. Reason for that is it is not binding. The recommendations of council are not binding, and because the recommendations are not binding, the federating units don't take the council seriously. Many a times chief minister of the state, even when the meeting happen, do not represent their state. It is some other minister or a bureaucrat, a civil servant who attends the meeting. Frequency है नहीं meeting का. Even if the meeting take place, the real exerciser of power, that is chief minister, does not attend the meeting, and that is why the implementation effectiveness of the council basically gets compromised. You can write how reforms can take place so that the council can work in a better way. For example, you can mention, आप mention कर सकते हो, you can basically mention कि what can be done is a timetable can be set with respect to the meetings. Second thing what can be done is the recommendations of the council may be laid on the floor of the house, on the floor of the both houses of the parliament, and also in the state legislature, and along with that what will go memorandum with respect to the effectiveness or with respect to the implementation of recommendation of the council. What it will do is it will basically provide pressure that is needed for taking the recommendations of the council seriously, for the purpose of taking recommendations of the council seriously. So this is basically about interstate council and it being advisory, rather than effective. Alright, now we will move on to the next question of the day. Next question that had been basically asked to you in OPSC examination. All right. Examine the provisions of social justice as incorporated in the Indian Constitution. All right, this is the question that you are expected to write answer upon. Just give me a minute. If there are any doubts, please let me know. If there are any issues with respect to this question, please let me know. If there are any issues with respect to the discussion, please let me know. We will take that into consideration. We'll basically take that into consideration. Okay. What basically is social justice? What basically is social justice? That has to be taken into consideration. On the basis of this definition, then we will move on to how Indian Constitution or Indian law basically catalyzes. Okay? How Indian Constitution basically catalyzes the implementation of social justice. So social justice, my dear friends, is providing for provisions that basically do not deprive an individual an opportunity because of his social background. Because of the social background. That basically is social justice. Now, social justice is an important concept when it comes to India being a welfare state. It is an important concept with respect to the provisions pointed towards India being a welfare state. And for that purpose, and for realization of India to be a welfare state, and for that purpose, therefore, what has to be done? The Indian Constitution must contain the provision. The Indian Constitution basically must contain the provision which will help in realization of that particular goals. Now, when we talk about social justice, when we talk about welfare state, when we talk about Indian Constitution, what should come in your answer? Which provisions basically you should target? You should basically target the provisions related to fundamental rights, provisions with respect to fundamental rights first and foremost, and then provisions related to directive principles of state policy. And provisions related to directive principles of state policy. All right. So with respect to social justice, with respect to directive principles of state policy, take it to specific provisions. Take it basically to the specific provisions. All right. So for example, Indian Constitution through fundamental rights, what it does? It creates an orientation towards equality. Mention Article 14 to 18. Basically creates a general orientation towards equality. What it does is it discriminates, it eliminates discrimination. It basically eliminates discrimination towards a particular person because of caste, religion, sex, or place of birth. More or less, these are the provision. Also you can add race and creed. All right. So all the social dimensions basically are covered. All the social dimensions basically are covered when it comes to social justice. All right. Not only that, what it also does is, for the purpose of social justice within fundamental right, we have provisions for special provisions. Like, justice basically does not depend upon everybody being treated the same. On some occasions, justice will arrive to justice when some communities are provided with extra benefit. Some communities basically are provided with extra benefit, and that is what we also try to do with respect to special provisions. Okay, so there are special provisions with respect to providing reservations for people belonging to SCs and STs. There are special provisions with respect to people belonging to other backward communities. There are special provisions with respect to people belonging to economically weaker sections. Also, there are provisions with respect to providing special provisions for women and children. Also, what we see is elimination of discrimination against minorities. Because India is a secular country, want of social justice to the minority community is also provided by the Indian Constitution, Also, what it does is, it basically gives you fundamental rights, gives you not only the rights but also the right to protect those rights through Article 32. So if social justice provided to fundamental rights is in any way affected, what will basically happen is you can move to the Supreme Court and through Article 32. All right. So that is how basically social justice is incorporated in the Indian Constitution through fundamental rights. More importantly, it is also done through DPSPs. Okay. When it comes to DPSPs, what do we see? We see elimination of or orientation towards elimination of social injustice through Gandhian, socialist and liberal outlook. Alright, Gandhian, socialist and liberal outlook. What we see with respect to DPSP is focusing on elimination of social justice through these particular ideologies. Ab yahan pe what you can do is, you can bring up one or the other DPSP and show in a specific way how this particular DPSP is used to counter social injustice. For example, in liberal, something in news, that is Uniform Civil Code can be taken into consideration. Okay? Uniform Civil Code can be taken into consideration, and how basically Uniform Civil Code, idea of Uniform Civil Code tries to do away with social injustice that has been effectively incorporated in Indian society because of religion, because of not religion as such but personal laws of different religion, all right, which are more or less inclined towards the male community, Same goes with socialist, where more or less it is tried to be done is social parameters are said to be such that create equality for different sections of the society. For example, equal pay for equal work. It is economic. The directive principle moves towards economic justice, but it is on the basis of economic justice that social justice will be basically achieved. All right. So this is the answer to the question. Moving on to the next question, guys. This is the question that Abhishek sir will take into consideration, where he will basically, help you in understanding help you in understanding good governance and social justice. ठीक है. Now we will take into consideration legal status of women in India. देखो, this question should not be asked for 8 marks or 10 marks or 12 marks. Basically an essay can be written on it, but still we will try to comprehend ourselves on the basis of the topic provided, the question provided. Legal status of women in India. Legal status of women in India. Basically, if you take into consideration legal status of women in India, so women are equal citizens. Women are basically equal citizens. They are not concentrated upon they are not discriminated upon, not concentrated upon, I'm so sorry. They are not discriminated upon by the Indian Constitution. They have same political, economic and social rights as their male counterparts. ठीक है, they have the same political, economic, they have basically the same political, economic and social rights as their male counterparts. Not only that, you have, if you want to give specific example, na, do mention provisions related to right to equality. That is 14 to 18. Also, through 23, Article 23, what has been done? Exploitation of women has been prohibited. Basically, exploitation of women has basically been prohibited. Moving on, so it is not only, देखो, it does not want you to answer constitutional status of women, na, it wants you to answer legal status of women. It basically wants you to answer legal status of women. So not only constitutional provisions, you have to basically move ahead and basically mention about legal provisions also. So it is important for you to mention certain other laws also. For example, laws related to domestic violence. Laws related to domestic violence. So we do have Protection of Domestic Violence, Protection of Women from Domestic Violence Act 2005. So mention that. Mention how legal remedies are provided to women through this particular law. Also, for the purpose of their focus or their participation in economic activities, so that it can be elevated, what has also been provided to them? Laws like Maternity Benefits Act. Laws like Maternity Benefits Act. For the purpose of they've been secured at workplaces, what we basically also have, the POSH Act. Prevention of sexual exploitation or prevention of sexual harassment. ठीक है, for the purpose of women being given better representation, what we have done is we have provided reservation for women in decision making. We have provided for reservation of women in decision making. When I say decision making, it is with respect to Panchayati Raj institutions and now also Parliament and state legislature. parliament and state legislature. So if you basically mention all this constitutional provisions and provisions with respect to different laws in India, what it will do is it will provide for better understanding to the examiner that you know what the legal status of women in India is. Also in it, I will expect you to write about property laws, especially Hindu Succession Act. What is expected from you to write about property law? All right, especially Hindu Succession Act. This will be more than enough for the purpose of you showcasing what the legal status of India, what the legal status of women in India basically is. Okay. Okay. Let us now come to the next question of the discussion. Let us now come to the next question of discussion, and this question is with respect to what are the constitutional provisions of social justice guaranteed in India. Okay, with respect to constitutional provisions related to social justice, वैसे ही one of the questions has to a certain extent provided for the same, more or less the same content. But ठीक है, they have asked us the question. So what we will do is we will in a more focused way, we will get into social justice and the way it is guaranteed, how it is guaranteed. When I say guaranteed, basically guaranteed, it has to be fundamental rights. ठीक है, because in a way fundamental rights are something that are compulsorily implemented. They are something that is compulsorily implemented, and because fundamental rights are they are compulsorily implemented, we have to focus on fundamental rights itself. हमें focus करना है fundamental rights पे. All right, so what has to be taken in consideration over here? What has to be actually taken into consideration over here? First and foremost, mention कि social justice वैसे तो Indian constitution basically is not just a legal document, it is also a social document. And basically being a social document, what it also basically portrays is an implementation towards social justice, with the point of view of some of them being guaranteed by the constitution. Some of them being guaranteed by the constitution. All right, so let us take that into consideration. Social justice, social justice and how it is basically guaranteed. Some provisions of it are basically guaranteed by the constitution. So first and foremost, take into consideration Article 14. What Article 14 basically does, it eliminates any kind of discrimination. So what it provides for is, first and foremost, it basically provides for equality before law. Equality before law. And second, what it also provides is equal protection of law. It provides for equal protection of law. ठीक है, through this Through this, what we basically see is any kind of social injustice being implemented towards a particular section of the society is done away with. Then we come to Article 15. Then we basically come towards Article 15, and what basically is done through Article 15? It prohibits discrimination based on specific social parameters. We have discussed that in one of the answers, but it requires to be mentioned over here. And what are those specific parameters? Religion, race, caste, sex, or place of birth. So these are specific provisions on the basis of which special injustice is prohibited. And most importantly, mention about Article 16. What it does is, it makes untouchability punishable. It basically makes untouchability punishable. And as it makes untouchability punishable, what is important for us to understand is it eliminates the gravest social injustice that Indian society has ever produced. Alright, the gravest injustice that Indian society has basically ever produced. Not only that, now these were basically, steps taken to avoid social injustice, and create social justice. But there are basically few more positive steps also. Now, for example, Article 15 and 16, both in Part 3 of the Constitution, what do? They provide for reservation. They basically provide for reservation. So that those people who have been left behind, they can be provided with positive discrimination. There basically can be positive discrimination in favor of them. There can be affirmative action in their favor, and they basically can move ahead with respect to the other communities basically of the country. Also, what you can take into consideration is Article 21A. What it provides for is right to education. Through this provision, the existing social inequalities or existing social injustice can be taken care of, All right. So these are certain provisions that are guaranteed. There are DPSPs also. But DPSP are not justiciable. So I will not take them in the category of, not take them in the category of being guaranteed. These provisions are basically guaranteed of the Indian Constitution. Moving ahead, guys. Okay. So these were the questions related to polity. These were basically the questions related to polity. All right. Thank you so much for being part of this discussion. We'll meet soon. Bye.